Okay, so welcome back to my channel, Iron Sharpens Iron Council, where it's all about uplifting and empowerment. So I don't have I usually have a video description, kind of like a script, but I literally can't find it.
Oh, sure.
So I just have to wing it, Charles. So guys, I have a special guest with me on video. Here, his name is, well, I'll let you introduce yourself. Go ahead.
Hello, this is Charles Booker, author of Chain to the Sky.
Yes.
How's everyone?
I'm gonna have a link, the Amazon link for Charles' book. Everyone highly recommend it, and you should get it. It's gonna be through the Iron Sharpens Iron affiliate link with Amazon. So yes, a sale will benefit us. But I appreciate the support. Okay, so getting on with the getting on. So unprofessional, right?
That's all right.
But
you'll get together in a minute. Don't worry about it.
Yeah, I just like our recordings to be real chill and real, just down to earth and very conversational, And so, I hope you don't mind if I chew in your ear, because I'm like addicted to chewing gum, especially doing my interviews. That's just like my go-to, my safety net. So I'll try to.
I can't hear it.
Huh?
So don't worry, I can't hear it. Go ahead.
Yeah, that's because I'm keeping it to a minimum. I'm not trying to hurt your ear. Yeah, you can't see me, but I'm like, I'm trying to not ear. But I appreciate you coming here, brother. I really do. I know that you and I talked off camera about the debt discharge with the $1 money order, and I just want to say to everyone, to the world, that because of Charles, I was able to confirm that what I wrote up was perfected, and it worked for me, and obviously it works for him. So I don't know if you wanted to go into how you came about that, how that information came to you, and why, why you used it and all of that. I like to get personal and specific, because as I was just telling you off camera, processes change. So I don't like to go in depth, like instructional videos. I like to go into what you did and what I did and keep it personal to us. And then that way it just kind of remains evergreen, because it's our story, it's our journey.
Yes. Okay, so briefly, what started me on my journey, oddly enough, was a traffic situation. A female that I was dealing with a few years back. She was working at a store. The store got robbed, and I was going there to provide some moral support. And on my way there, I was speeding, and the officer pulled me over. I told the officer to call the store, call the precinct in the area, find out what happened. He didn't want to hear anything I had to say, so he wrote the tickets. He even gave me a no insurance, and I had insurance. Insurance company drug tailed to actually get the information to the courts. So they hit me with all kind of fines and fees. So after doing that, I was looking up how to address court cases, traffic court cases, and how to take care of those fines and fees. And I came across a number of videos on YouTube. So after watching a few videos here and there, I realized, like, one, you didn't need a license, in order to operate a vehicle. And so I started studying that, and then I came across an individual who explained that he was paying off his traffic tickets with postal money orders and negotiable instruments, and he didn't have to spend any money out of pocket. So I started studying that, and that also led me to contract law. So as a result of these events, I just delved all the way into that particular field, and it culminated in the book Chain to the Sky. How to discharge debts through the use of postal money orders.
Oh, okay, that is amazing. I mean, just basically just your typical one thing led to the next, and then you just kind of, went deeper.
Yeah, yeah. Yeah, so I kind of branched in different areas. Again, contract law, negotiable instruments. I also studied a little bit about the aspects of, status correction and also I have a few recordings of me in court. Basically doing the back and forth with some judges and some things like that. Had one. Yeah, one recording actually. I had the judge actually stuttering. He didn't know what to say because what he was trying to do is he was trying to alter the law. But what happened was I had quoted the law word for word, and so he was trying to change it. But every time he tried to change it, I would interject and I would object, and then basically requote the law. So whereas he basically just got out of the discussion and just changed the whole topic.
That's that explains to a T almost with my evolution and learning law and learning that it is a man sitting in a row and you're relying upon his interpretation. But we all have interpretations of the law at the time, and so I started to learn defend myself. I mean, we shouldn't even have to defend ourselves, but in this wayward life that we're living, we have to the way things are set up. We have to defend it's set up in such of a aggressive what is the word, aggressive way that we have to defend ourselves. And so if you just stick to the letter of the law, they cannot rebut that. And so I experienced that. I experienced that with a judge in Virginia. And when I started submitting, corrected paperwork with the correct language and the correct verbiage, I noticed that her stance and her firm position with me started to soften. Now, I'm not saying it's going to be quick or magical or easy. It's not. It's like you have to claw your way all the way to make sure that they understand that you understand who you are. And so, it just takes time. I mean, this stuff is just it's just a matter of having that confidence in your level of understanding. Even if I have to read, I used to do that. I used to have to take paperwork in with me and just read from it. I'm like, okay, hold on, give me a minute, don't rush me. Equality is mandatory by law, so give me time.
And that's one of the things that we we share with the people that study with us is that you want to always be careful of a traverse because they're always trying to get you to traverse, which is, basically fall on one side or the other side of the pendulum. You know what I mean? So if you're silent, then you traverse. If you speak the wrong words, then you traverse. So you always want to be careful on, going into those courtrooms and knowing what to say and making sure that what you say is spot on, because this is something that I like to share with a lot of people that study with me, is that, they're trained. They are trained. They're specialists. They have a PhD in finding flaw. They have a PhD in finding flaw, in deception. So as soon as you make an error, their training, it's all about looking for flaw. So as soon as you make a flaw, they capitalize on it. So you always have to tread. You have to tread lightly, and basically cross all your T's and dot all of your I's.
Yes, they're looking for a single error, and they will make a mountain out of a molehill with that one single, and build a case around that one error. And so just like how we were talking about it off camera, whatever they do to us, we have a right to do back to them. Okay? And
equal protection under the law.
Exactly. Yes. And that comes for, and that is in every walk of life. I mean, it could be you're dealing with a credit card debt, you could be dealing with traffic court, you could be dealing with court. Equal equal opportunity under the law is mandatory.
There was I had made a video on my Facebook page, the Legal Crest. I made a video on that dealing with the bonds. You know what I mean, about the court cases and stuff like that, showing how they actually monetize the court cases through the trust fund journal. They have a trust fund journal that the judge and the clerk of the court, they're able to put their eyes on it. Most prosecutors don't even notice this thing exists. They don't even realize that this thing actually exists unless they're like higher into the rankings. They may be becoming a judge, or they're going to be somewhere high up in politics, something like that. But the trust fund journal is actually, it's a document that at the top of it says basically the people versus, and then it will have the person's name, and then it will have the attorney's name, and then it will also have the bank name, and then it will also have an amount for the court case. And then they just and it has the different lines going down, and that's the tally. They're actually tallying up what the court case is running, how much it's going to be, and all these other things. And you would need the bonds, namely a bid bond, a performance bond, payment bond, appearance bond. Those are some of the main ones that are needed for the case. The bid bond is used to actually bid on the case. There are a number of individuals who know about this thing as far as the bidding on cases, and that's what they do. They bid on the case, and the one who comes out with the highest is just like an auction. It is exactly like an auction. So they bid on the case, and the one who bids the highest on the case, they have control over the case. They have control over the case. Go ahead. You just want to say something?
Well, I definitely, I'm aware about that, but I'm very leery about bringing that to public because I prefer to stick to
the financial aspects. I think I'll just throw a little tidbit in there because it is dealing with the financial aspects. I understand. You want to deal with the discharging of debts and things of that nature?
Well, just your own journey. If you've done that, if you touched on that with your case, then fine. Just kind of relate it back to your personal journey. That's all I do. I don't want to be teaching. We have a lot of mysteries that we can unravel. Like it'll take just a quick 2 hours of deep dive. But no, seriously, I've learned to understand what the fraud and how to unravel the fraud. It's all about reversionary interest. But I don't, and I don't want to go into all of that because then we're sitting up here telling grown folks what to do, and I don't do that.
Oh no. We don't do that. But okay, so
after. We have links. I'll have links to your Facebook page. I'll have I'm very sharing and promotional. I love sharing with the people. If you have remedy and you have solutions, hey, we will put it out there. You ready for it? You ready for it, Charles? You will have it. I will put the links and everything.
Sounds like a plan.
Plan. I love supporting people that want to support other people. So that's how we.
As far as personal experiences, as far as discharging debts, I've done a number of different student loan debts by using affidavits.
Yes.
Child support, namely my father. I had a brother who had passed away back in 2005. My father, they were still charging him even after he died. It was like $57,000. And
sorry, I'm so sorry.
Yeah, it's all good. No, because he's very happy right now because he paid it all off with $20. Yeah, we used I told him to go get a $20 money order. Go get a Postal $20 money order, because the post office does not belong to the United States. It belongs to Bern, Switzerland. It's not the property of the United States, even though it says U.S. Post Office. But again, you have Bank of America.
It's a private, for-profit company.
Exactly. And the thing is, Bern, Switzerland, the post office is one of the very, very, very few currencies that is still backed by gold. So, yeah. So when the dollar crashes, I would suggest that everyone go get postal money orders, because the postal money orders are actually still backed by gold and silver. So hurry up and get to the post office when that dollar crashes. Hurry up and get to the post office and buy postal money orders. So
okay,
that is
can I just interject really quickly on just to
go ahead. Yeah.
I just want to piggyback off of the backed by gold statement.
Yeah.
Very, very true. But for those who let's say they just can't afford to do that right now, even to buy a money order right now, because we have brothers and sisters out here in these streets really struggling. Okay, so if you don't have the means to do that, a really quick and simple way to access, you know, the lawful money, because gold and silver is the only lawful money. So
Correct.
so in order to redeem that, there's a clause in the Constitution called savings to suitors, and that savings to suitors clause allows you to redeem lawful money. All you have to do is simply write on the back or endorse on the back, pursuant to 12 U.S.C. 411. That's it, and you have access to lawful money just like that.
You do that on your paycheck. I do it all of my paychecks. I do it on the back of all of my paychecks. I have a stamp. Yeah, I stamp the back of the paycheck, and you know, I'm demanding the money to be paid in lawful money. You know what I mean? And
exactly.
You know, initially, you know, you'll run into some problems, what have you. You know what I mean? But once you explain it to them, and a real brief way of doing that is just, you know, when they ask you what is that about, you say this is for the IRS. You know, it's just something for the IRS. You know, the IRS needs this. You know what I mean? And they usually just like, oh, okay, and they just let it go. But so now, so dealing with the money orders. So basically, you have a law, so UCC 3-311. It's accord and satisfaction. Basically, you know, it states that you know, the individual who can prove that they tendered a payment, you know, for a specific amount. You know, they've done it in a very conspicuous way, and the definition of conspicuous is, you know, a different typeset, different color, different font, different size. All of these different things are considered conspicuous. So it has to be something that draws attention to it. So it says when you've written a conspicuous statement on a negotiable instrument in order to tender a payment, then you know, and it says it's done in full satisfaction of the payment, you know, similar to paid in full.
Yes.
Right?
Yes.
Paid in full. That actually, there are court cases where individuals have put that on checks and money orders and paid off companies. McMahon versus Dairy Barn. You know what I mean? Where, you know, paid in full and upon receipt. These are different terms that were used. One particular case, a gentleman, he hired a construction company to remodel his entire house. And it came up to like $300,000. And you'll find this in Westlaw. It's not a, you know, it's nothing that's it's not hard to find.
Okay.
But anyway, he hired a construction company to remodel his house. It came up to $300,000, and then he sent them $100. He sent them $100 check, and basically it stated, you know, upon receipt, you know, this is the final payment.
Mm-hmm.
And they obviously the company wasn't very happy about it, so they took him to court. The judge asked him, you know, did you receive the payment? He's like, yeah. Did you cash it? Yeah. Said, you've been paid. They didn't like that decision. They appealed it. They appealed it all the way up to the Supreme Court. And the Supreme Court said the same thing. Did you get the money? Yep. Did you cash it? Yep. Okay, well, then you're paid. And rehearing denied.
Yeah.
So they can't even reappeal. They can't even bring it back to any court. It's done. It's over.
Right. The technicality is called that the man won based on it. It was accepted for value. It was accepted for the value that he
right.
Yes, and they didn't refuse. They had opportunity to refuse it for cause. They did, but they didn't. So
see, here's the conundrum for that. Here's the conundrum concerning that. The thing is, okay, now if they refuse, if they send the payment back, right? Mm-hmm. It falls under a number of different categories. If they take the payment and they cash it, then the accord of satisfaction takes effect.
Right.
Unless it has been subject to liquidation, which would be it's been sent to collections, If it hasn't been sent to collections, then has it been concerned with a bona fide dispute, which would be a court case where a judge makes a ruling and orders the individual to pay the amount. So if those two aren't a factor in it, then the accord and satisfaction will in fact work. Now, the only issue that the individual may have is that some companies may want to test you, or some companies don't know. So usually there's a number of ways of handling that. To be brief about it would be basically to explain the usage of an affidavit. So you would use after you made that tender of payment, you would submit an affidavit, an affidavit of validation of debt. And essentially what you're saying is, I need you to validate this debt. Not that I don't believe that not that it doesn't exist. I'm just saying that I don't think it exists based upon my records. My records, show that, I tendered a payment and there should be no debt based upon this. And then, in the affidavit, you would add the tracking number, because usually we don't send it to them certified mail, because they usually don't give you a name. And for certified mail, generally you need a name in order to send it certified mail, especially for a return receipt. So what we'll do is we'll just send it regular mail, but put a tracking number on it. So now you're creating physical evidence of your efforts. You know what I mean? And that's what the law dictated. It said the individual to whom, upon whom a claim has been asserted, that would be us, proves. So you have to be able to prove that you actually made this, you tendered this payment.
Right.
So that would be your tracking number. And you also make a copy of the money order before you send it off. If you
what
want,
tracking number do you use, Charles?
I'm sorry?
What tracking number do you use?
Just a standard tracking number. You go to the post office. It's a green and white card. You fill out the green and white card. The number's on there. They're gonna put it. They're gonna take the sticker off, put it on the envelope, and then give you back the card with the other number on it. And then they'll give you a receipt with the number on it.
You mean are you talking about the certified? Okay, I thought you said don't use the certified mail.
No, you don't use certified return receipt. You don't use certified return receipt. Because this is just the payment. You're just going to send off the payment. So you're going to send off the payment. It's going to come like regular mail, but it's going to have that tracking number on it.
Oh, okay. I see.
So now you have evidence that you mailed it off, and you also have evidence that it landed. They received it. So what you're doing is, you're essentially building up your case before you even get to court. Because right. Again, court begins in the mail.
Absolutely.
Court begins in the mail.
Let's talk for a second about if they return the instrument.
Okay. Yeah. So once you send it off to them, they receive it, and if they there's a couple of ways that they might want to send it back. They'll send it back, basically stating, they'll send you another bill, and act like they'll make a deduction, but they'll just send you back another bill. All right. That way you would handle that with an affidavit. The other way that they could send it back, they would send back your money order, right? If they send back the money order, then you would send them an affidavit letting them know, hey, you just fell under UCC 3-603. I offered a tender of payment.
Yes.
For the complete amount. Now, what happens is a lot of individuals, they read UCC 3-603, and it says, that the debt is discharged to the amount of the payment tendered. Well, I tendered it for the full payment. So it's not the amount of money that I sent them. It's for the entire payment. I sent that for the entire payment. So the entire payment is discharged.
Yes, it's accord and satisfaction. It falls under accord and satisfaction. People think that it's just for the amount that's due, but no, it's the full payment. It's a full discharge.
Exactly.
Yes.
Exactly.
Mm-hmm.
So now if they try to send it back, then again they fall under UCC 3-603, which says if they refuse it, then the whole debt is discharged to the amount. So the amount is for full satisfaction. So that's it. The whole thing is done. So the other ways they can send it back is they can send it back with they can actually make their own check and send it back. That's when you're dealing with like a corporation and stuff like that. But basically, they would need to have put inside of the contract, the original contract, or had sent you a notice in the mail before you made your first payment. And you have to keep that in mind. It's before you make your first payment. They must put that conspicuous statement. This statement also has to be conspicuous. A conspicuous statement stating that all payments of accord and satisfaction, this is the law, all of their payments are to be made to a specific address or a specific addressee. Now, if they've done that in the original contract, this is why we're supposed to read these contracts. If they've done that in the original contract, then they have a valid argument and they can reject your accord and satisfaction because you did not send it to the designated individual or designated address.
Right, as specified in the original contract, but they
they
don't address those things, so there's the loophole. Guys,
right.
This is not legal advice. This is just two friends, a brother and a sister just chit-chatting, and we're hoping to share our knowledge and our actual experience, okay? It's not legal advice, so go ahead, Charles.
I never give legal advice. This is just me talking to myself, and you know, that's it. You know, anybody, you know, whoever reaps a benefit from it, you know, that is purely from your own mind and thoughts. And I appreciate you, you know, taking the time out to hear me. But I advise you to do your own research.
Due diligence.
You know what I mean? And,
due diligence.
Yeah, and never take any advice from me. I don't give good advice. All right. So so basically, just, you know, briefly to go into my father's situation. So so he had a child support situation. He sent the money order, $20. About a couple of weeks later, maybe two and a half weeks later, he gets a letter in the mail. They send a letter in the mail. The bill has been reduced to $21,000, and and they sent him a warrant.
What was it before? What was it prior to 21?
It was $57,000.
Woo! Okay.
Yeah, it was $57,000. So we sent them a $20 money order. They realized, hey, wait a second. Okay, well, maybe we don't need the whole 57. Why don't you just give us 21,000? So
they tried to renegotiate.
Yeah, that's what they're doing. Trying to recontract. That's exactly what they're trying to do. That's what they do.
That's called
so they'll try to call you. They'll try to send you something in the mail. Try to scare you up. Okay, but I've had situations because I've also had child support issues before. And I've actually revealed them for who they are. I sent them a debt letter. This is before I even sent them a money order. I sent them a debt letter, and I told them, you know, listen, you know, if there's a debt, prove it. You know, I want all my documents. I want a wet bluing signature. I want certified copies of everything. You know, I want the documents. Yeah, I want the documents to be sent. By any rebuttals have to be sent by affidavit, and no other documents will be considered valid as far as a rebutting tool. You know, so what did they send me back? They sent me back a bunch of paperwork, court names, court and all this other nonsense. Yes. Nothing was signed, not even the judge's name. Not my signature, not the judge's signature, not the what do you call it? The law guardian signature. Nobody's signature whatsoever.
Wow.
No one's signature. No, nothing. Nothing was certified, nothing. And so, you know, I basically sent them another letter, you know, affidavit of fault, opportunity to cure. And I told them, you know, listen, you know, I just received your paperwork. There's no documents. It's not documents. You give me a bunch of paper. Yeah. I received the paperwork, and, you know, it's glaringly obvious that you have not responded nor rebutted any of my presumptions. I'm sorry, any of my conclusions in law, and therefore, you know, you're presently at fault. You know, you and every agent involved, and you know, and I delineated a list of the things that I demanded on the first letter, and I said, you know, well, being that you're now in violation. Oh, I'm sorry. One more thing. I just want to, at the end of my affidavits, I like to put at the end of my affidavits, you know, if there's any misleading information, lies, false or deception, anything like that, it's I would put $200,000 for each occurrence of those things. So when they mailed,
time is your property, and they just can't
Exactly. So I sent them back. When I sent back that second affidavit, the affidavit of fault, opportunity to cure. I made it clear to them, you know, you've engaged in false information, misleading information. I just ran it all down. 200,000, 200,000, 200,000. None of the documents are certified. So each document, they give me about 15, 16 pages. Each document that was not certified or signed, that's 200,000. So if it's not certified, it's 200,000 for 15 documents. If it doesn't have signatures on it, that's 200,000 for each document that doesn't have a signature.
Yeah. So each document had about 3 or 4 violations for every single document.
No, 10. Each page had 10 violations.
Wow.
So that's 10 times 200,000.
Yes.
So now when I gave him that, and I tally everything up. It came up to him. I just threw a figure out, just like 7 million, right? So I just gave it back to him, and I have not heard from them since. Yeah, my credit score went up. They had my credit score beat the crap. My credit score was like 450, something like that. It just kept going. It was like 676.
That's right.
and it's still going up. So that's with that. So the similar situation happened with my father. The only thing is that when they sent him the letter back with the quote unquote warrant, it's a non-arrestable warrant. So we have another stamp that we have. Basically you're going to accept it for value and honor. You fill out your information on it and you send it back to them. He sent it back to them. He hasn't heard from them since.
That's right.
Oh,
yeah.
So
I have a powerful affidavit that I use with a warrant, and same thing. They left me alone. I'm like, whatever. Once you lose your fear, Charles, that's it. It's a wrap for them.
Right. That is exactly it. It's their whole system is ran off of fear.
Yes.
You know what I mean?
Yeah.
And just like you said, once you lose the fear, they become afraid now.
Absolutely. You've turned the tables.
It's like a bully. It's a bully. They're bullies. That's what they are. They're bullies. So once you show a bully that you're no longer afraid and you're actually prepared to fight,
yes.
Now you get to see, where the bully's heart is, and it's not there. It's really not there. It's really not.
Yeah, they're really. It's really the ultimate act of being a coward, because they hide behind, their little network, and and so once you lose your fear, that is the greatest gift you could give to yourself. And and the only way that you could do that is by studying, researching, and networking with like-minded people. And that's how I was able to grow. 3 years ago, I would have never believed that I would come to understand and see the fraud for what it is so clearly today.
Yeah.
But that's all it was. There's really no secret to anything special about me. I just study. I just, dug in, pretty much.
Yep, that's it. That's what it all boils down to. Are you willing to learn and educate yourself to the point to where you can actually see things for what they are? Mm-hmm. And then are you prepared to have the courage to act on what you have learned?
Yes,
that's it.
Courage to act and stand on it, and do not be moved. Do not be moved. And sometimes another one of my issues is starting stuff and not finishing. So I have to really be more disciplined, because I know that I just stated it to another sister friend in this fight. I said, listen, discipline is the problem and the solution, for me.
Yes.
It takes discipline. You have to just see the thing through. If you stepped out on step 1, you got to go through step 2, 3, 4, and 5. And sometimes you may have to take things to court. Take wrongdoers to court. Because they're not expecting that. They're expecting to exhaust you. They're expecting to have to see you quit, because they have an army of lawyers and the intimidation factor, and then they got the bully friends with the guns, and knock on your door and all of that. But no, don't quit. When you know that you're in the right and you're operating on the right side of the law, don't quit. They're expecting you to quit.
Exactly.
So the one thing I want to leave people with, because we got to wrap it up a little bit, is to take evildoers and wrongdoers to task. Don't quit.
That's right.
Don't quit.
Yes.
The one who leaves the battlefield first, loses. You have to out, and you might have to take it all the way to the hill. Hey, if that means going to court, well, doggone it, that's what that means. You have to fight to the end. And you reminded me of that too yesterday. So I thank you for that reminder and that confirmation that, you know, we have the strength, and we have, as long as we have the strength and the courage to finish what we started, oh yeah, we're gonna be undefeated, and we're gonna start winning, and we're gonna start changing minds and changing policy, and maybe make them become a little bit so afraid that they're gonna start doing right, because they've been doing wrong so long they think it's right, honey. They think
exactly, exactly. And they got the people convinced that they're doing it right.
Yeah. Across the globe, everyone thinks that, oh, look at this sovereign citizen, and calling us all kinds of names just because we're standing on the right side of the law. You know, it's just ridiculous. How they get away with it, because they have the attention of the media, and they like to vilify, you know, people who are standing up for what's right and what they believe in. You know, so yeah, I definitely have come a long way, because I used to be very aggressive in my writing stance, and I've calmed that down a lot over the years. Now I'm, very peaceful. You know, I give out my peaceful vibes in my letter writing style now. It's changed, you know, because I find that you mentioned it a little bit earlier, where each cog in the wheel, sometimes they don't know that they are part of a corrupt system. You know, they know and believe that something is wrong, but they're just doing their job. And when they say that, oh, I'm just doing my job, they are sincere. That's all they know. They don't know the evil and diabolical plots and twists that's running behind the scenes a lot of the time.
I'm gonna say this. Let me just add this one thing in there real quickly.
Okay.
I definitely agree. A lot of them, the majority of them, do not know. But here's the thing, and this is where they become liable. When the information is brought to you, it is your individual obligation to look into the truth of it. And when you see the truth, you must enforce the truth. Now, they tried that with the Nuremberg trials. After they beat Hitler or what have you. They got those officers and the generals and the captains and all that, and they was like, well, you guys did all these atrocities. They said, well, no, we were just following orders. That doesn't fly. You have an individual moral compass. You have an individual moral compass, and you are now obligated to follow your own individual moral compass.
Yes, that immunity is stripped once you are informed. You have valid information, you have the right to investigate, and now you are going to be held accountable. Oh, absolutely. Yeah, but I'm saying at the side of the road, if somebody pulls you over, that's just not the time to educate, my brother. I just like, okay, yeah. But when you present it in writing, now they have to look at it. Now they have to look at it, and all immunities are stripped. They can't hide behind the badge. They can't hide behind the oath. They can't hide behind any of that, and my title, and I'm just doing my job. Nope. Sorry. You have, I'm taking it to the hill. Okay. The situation was in reverse and I was in the wrong. You know what you do to me.
Exactly.
Oh man, well this was awesome. I appreciate you, brother. I'm gonna get your links and I'll put them in the description box, because I want everybody and anybody who's within the sound of my voice to definitely reach out to you if they so choose. And I welcome you to come back at any time. I just want to close down real quick by reminding people that the peaceful is the way that I promote and I teach. I can't tell you what to do, but I have gone a lot further faster by being peaceful. Okay. Right. Belligerents have rights. We have power and authority. How about that? Yeah, all this. That's my right. That's my right. I don't say that anymore. I learned. I've evolved, but I get it. I was a beginner too. I was a newbie too. I get it. So I'm just trying to share the wealth of knowledge and information that I have.
The claim of "that's my rights," it usually indicates to them that this person really doesn't know their rights, because if you knew your rights, you would articulate them. Exactly.
Yeah, I read that quote a long time ago with the belligerents have rights. We have a real man or a real woman have power and authority. I was like, oh my gosh, that is so perfect. Perfect.
Mhm.
So
Yes.
I don't say that anymore. I don't use the whole, that's my right and you're trampling on my right. I don't do that anymore because I've learned, you know, when you know better, you do better. So I'm just trying to share. So,
Yes. Yes.
wow, this was jam-packed with gold nuggets. I hope that the audience who listened, you know, is really edified and uplifted by this. Thank you so much again, Charles. Oh, you are a breath of fresh air. So
You're
willing,
welcome.
so giving, and I hope you get a lot of people reaching out to you and you know, and help you out in that way. So
Thank you.
on that note, guys, I'm just going to close out here, and I'll see you on the next session. Charles, hold on while we'll get off camera. So I'll see you guys on the next video. Thank you for supporting. Please, if you're new to the channel, subscribe, like, and comment. Let's have a discussion and comment. Positive comments, you know, positive, you know, peaceful comments are responded to. Negative comments are not. I read them, but I don't respond to them. So you're just pretty much wasting your time with a negative comment. So yeah. All right. Peace out. Next time, and be safe.